Welcome. This is D.L. Hughes from VelocityWriting.com, where you learn to write with speed, passion, purpose, and profitability. Copyright laws are confusing to many writers. They are fairly straightforward to follow, however. In this video, you learn what copyright is, what you can copyright and what you can't, the cost of getting extended copyright protection, and much more. Copyright facts are coming up right now. I'd like to invite you to subscribe to my channel. Be sure to click on the bell icon to get notified about new videos. If you gain helpful insight, please click like. Also, your comments are always welcome. Copyright laws differ. I'm not a lawyer and I'm not offering legal advice. What I discuss here applies to citizens of the United States. Now, there are international copyright treaties, but copyright law can vary in other countries. Now, the protection of a particular expression of an idea did not become law until Queen Anne's statute in England in 1710. At that time, an author would write a book and receive a small amount of money from the printer. Once the book was published, other printers made their own editions and the author received nothing from sales. Queen Anne changed all that. She dictated that authors held the exclusive right about who could make copies of their books for a term of 14 years. And the author could sell it to one or many printers and reap the economic benefits. After 14 years, anyone could reprint the book and make money with it without paying the author. After 14 years, the book entered what is known as the public domain. Now, when the U.S. Constitution was written in 1787, the Founding Fathers agreed that creative people deserved protection, and copyright is included in Article 1 of the U.S. Constitution. Now, copyright allows you to sue anyone who infringes on your right to make copies of your work. Copyright laws change. Copyright law is continually changing. Old laws no longer apply, even though many people think they do. For example, according to the 1909 copyright law, which lasted until 1989, you had to properly document your ownership. That meant you had to put a line like this on any work you intended to protect and to register the work with the U.S. Copyright Office. However, since 1989, you do not need to use a copyright notification like this. It's optional, but I think it's best to use the copyright symbol with year and your name. You can't go wrong by doing it. One of the biggest changes over the years, of course, is the extension of time that things remain under copyright before they go into the public domain. As you know, it started at 14 years, and now, as a general rule, for works created after January 1st, 1978, copyright protection lasts for the life of the author plus an additional 70 years. Now, there are other changes, of course, but these are big. You have automatic copyright protection. Now, most aspiring writers don't realize that they have automatic copyright protection the moment they put their work into tangible form. You're covered the moment you put your ideas on the page, canvas, musical score, or whatever your form of expression may be. You are covered without registering your copyright. You don't have to pay a fortune to register a copyright. Now, even though you're not required to register your copyright with the U.S. Copyright Office, you must register it if you want important expanded copyright protections. It is of particular importance that your copyright be registered if you take a third party to court for copyright infringement. Now, I have seen companies, especially those pay-to-publish vanity publishing companies, that want to charge writers $150 to $250 or more to register a copyright. Well, that's robbery in my opinion. The process is simple and anyone can complete the form at the U.S. Copyright Office website. And the cost? Well, it's only $45 for the basic registration. That price is subject to change over time, like everything else, of course, but it's a reasonable fee. By the way, it may take you up to 6 months to receive confirmation of your copyright, but not to worry. You're still covered if your paperwork is in order. There are forms of expression you cannot copyright. Now, here are things you cannot copyright. You cannot copyright an idea, calendars, telephone directories, height and weight charts, lists and tables from public documents, rulers and tape measures, list of ingredients in recipes or formulas, blank forms, including things like address books, order forms, and so forth, or you cannot copyright anything already in the public domain. Now, there's a lot of confusion surrounding the fact that an idea cannot be copyrighted. That's primarily because you hear of court cases where someone claims that a filmmaker stole an idea from a writer. These cases rarely succeed if no copyright infringement takes place, simply because you can't copyright an idea, only the expression of the idea. Some writers claim plagiarism, but plagiarism in the U.S. is not illegal. Plagiarism is simply bad manners unless copyright infringement can be proved. If someone takes your idea and transforms it into something unique, well, then you have no rights. The types of works you can copyright. Here's a list of things you can copyright: audio, literature, architecture, video and film, choreography, music, drama, pictures, graphics, and sculptures, and computer code. Copyright law does not cover everything. It's important to know that there are other classes of protection. For example, you cannot copyright business, organization, or group names. You cannot copyright product or service names. You cannot copyright titles of works, like the title of your book. You can't copyright that, or domain names. You cannot copyright slogans, mottos, or catchphrases. In each of these cases, the people who own these kinds of intellectual property need to apply for a trademark. A trademark is generally a word, phrase, symbol, or design, or a combination thereof, that identifies and distinguishes the source of the goods of one party from those of others, according to the U.S. Trademark Office. By the way, there is a third kind of intellectual property protection. It is the patent process. A patent excludes others from making, using, selling, or importing an invention throughout the United States without the inventor's consent, and that's according to the U.S. Patent Office. So, when it comes down to specific cases about questionable matters, you should consult with an attorney who specializes not in real estate, but in intellectual property rights in your geographical area. Copyright protection should be important to all creative people. We deserve copyright protections so we can make the money we need to keep on creating. Have a great writing day.